Good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Yes, I'm on a little late just because it has been a busy week so far, but I still want to touch base with you and to be able to answer questions and talk about topics that may interest you. So today I'm going to answer a question that seems simple in theory, but it is really a complex question. But it is one of the common questions that I get, and people are really surprised at how complex their situation is when we get to, especially when we're in a consultation, and I have to explain what they have to go through to get to the point where they can get the green card through their US citizen parent. So, usually the general question is I'm here. I'm here in the US. I have a citizen parent. Can I apply for the green card while I'm here in the US? And a lot of people will be shocked for me to say, well, it depends, right? They will say, but the parent is a citizen. And I then have to explain that even though you may have a US citizen parent, it's all whether you can stay here and apply through the parent. It's going to come down to a number of factors. What's your age? That's the first thing you'll hear me ask. Okay, so your parent is a US citizen. How old are you? If they are under 21, then okay. So there is a possibility. If they're 21 or over, we need to talk more, right? The other question that usually follows up after what your age is what's your current status? I know you're here in the US because you're saying you want to stay here and apply. Have you already overstayed your status? Have you entered the country with permission? Did you enter with a visa? Are you still currently on that visa? What kind of visa do you have? Right. And so my answer there is also going to depend on your answer there. Then the next is okay, you have a US citizen parent. Great. But what's your current marital status? If you are married and you have a US citizen parent, then that's going to affect the processing times. If you are not married, then you may look at a shorter processing time, but then we have to go back to your age, right? So if you're under 21 and unmarried, great. You're in a good position to be able to apply while you're in the US. If you're 21 and on 21 already or over and unmarried, then we have to talk more about what your immigration status is. So, as you can see, it's not a yes or no answer. It's all dependent on a number of factors here. So, I'm going to run through whether you I'm going to run through cases where you are able to stay here and apply for your green card while staying in the US. Now, if you have a US citizen parent, no doubt you qualify for the green card, but I'm focusing on can you stay here in the US to get that green card? And so the first rule of thumb here is if you want to stay in the US to apply for your green card, you will have to be able to show that you are made at the time that you're applying for permanent residence, that you have maintained your legal status. So say you're here on a visitor's visa. You cannot be applying for that if your visa overstays. I mean, there is an exception here, so I'm going to mention the exception, but that's the general rule, right? Now, what if you've already overstayed? So if you've already overstayed and you're under 21 and unmarried, that's okay too. You entered legally, but now you overstayed. So that means that you can apply for adjustment of status. That means stay here and apply for the green card while you are in the US. It's okay to do that because children of citizens who are under 21 and unmarried, they are the only children that can do that. All right, that they can be here without a current status, but they entered with a some sort of visa, parole, or some sort of permission or inspection. They can stay here and apply. But if you are 21 or over and unmarried, you're going to need to meet another requirement. So in addition to maintaining your legal status, you're going to also have to show that you have a current priority date. So if you're 21 and over, you're going to have to show current status at the time you're applying for adjustment of status, and you're going to have to show that you have a current priority date. What is current priority date, right? Sometimes you'll see it as PD. I like to put it simply this way. It's the date that you're given to put you in place on the wait list. There's a specific wait list for children of US citizens who are 21 and over, and it's going to determine your spot on the wait list. So when your priority date becomes current, it means it's your turn on the wait list. But right now, the wait list is 5 to 7 years, right? So what that means is that your current priority date has to be current right now to be able to adjust status. So if your parent has applied for you today and you're 21 and over, it's very, very unlikely that your priority date is current, because you have a 5 to 7 year wait on that wait list. And remember, you have to be maintaining your legal status in the United States to be able to stay here and get the green card. So it's very unlikely that on a visa, especially a B visa, you're able to maintain your legal status and wait for the 5 to 7 years to pass. So as you can see, in a case like that, you would not be able to qualify if your petition, your priority date isn't current, your turn on the wait list has not come yet. You cannot be here and apply for adjustment of status at the same time. And certainly if you've overstayed already, then there is a whole other process that you have to go through to get the green card. If you're here already and you don't want to face, harsh immigration consequences as a result of that, you have to go through a different process to get the green card. And I'll mention that a little further down. But right now I'm focusing on who qualifies, right? Who qualifies here? So I already talked about, if you're under 21, unmarried, then priority date doesn't matter there. You're the child of a US citizen. The priority date does not matter there. As long as you came in with some sort of visa inspection or you were paroled in, you have a US citizen parent and you're under 21, you will likely be able to adjust status, meaning stay here and apply for the green card. If you cross a border without permission or without inspection, then you also have to go through that other process that I mentioned previously. There's another process, but it won't allow you to spend the entire time here in the United States. So another thing is, if you are here and you're being mistreated by your US citizen or legal permanent resident parent, then you could possibly qualify for VAWA. Now, there is an age restriction here. You still have to be mindful of the age, and that's going to be, are you under 25? If you're under 25, then there may be a way for you to then still go through the VAWA process to eventually adjust status here in the United States. So if your parent, say your parent never filed for you, or they filed for you and they're here, they're mistreating you now, then that is a possibility. So VAWA, this is through VAWA. And VAWA is not just restricted to the spousal relationship. It's also for the parent-child relationship, where the parent is mistreating the child. So that's another exception to that general rule, that you have to be here with current status and you have to have entered the country legally to be able to stay here and apply for the green card. So if you're in a situation, my rule of thumb, if you're in a situation where you're being mistreated by your parent and you're under 25, we can explore that option to determine whether you qualify for VAWA. Because if you do qualify for VAWA, you can still move forward with your own petition and then apply for adjustment of status. Once the VAWA is approved, apply for adjustment of status to get your work permit, through VAWA, through deferred action, but then also to be able to move on to getting your work permit through adjustment of status, your SSN, and then your green card eventually. So as you can see, getting the green card through your citizen parent may not be a straightforward question if you are already here, especially if you're out of status. It's not to say that you won't be able to get the green card, but you definitely should get legal advice if you're here, you're out of status, you have a citizen parent, and you're trying to figure out the next step. This is what I do. I advise immigrants on ways to be able to get their status in the United States, even if you're already out of status. In complex situations like this, I especially advise and represent my clients on these types of issues. Now, what if you are, so we talked about having, if there are two categories, right? So if you have a US citizen parent, you are here with status, right? Your priority date is now current, then adjustment of status is a possibility. The others, if you're under 21, you're under 21, you're unmarried, then whether you're in status or out of status, as long as you came in legally or you were inspected at the border, then you also will be able to adjust status. If you are 21 or over, you don't have a current priority date, then you will not be able to adjust status. Also, if you're under 21, you have a citizen parent, but you came across the border without permission, you will likely not be able to adjust status. But for those who can't adjust status because maybe they crossed the border without permission, or you have overstayed and you don't fit within the exception, so you've overstayed and you now, if you leave, you're going to face harsh immigration consequences. There is what's called an I-601A waiver. So this isn't the same as adjustment of status. So now I'm just giving you some additional information, but it's an additional option for those who can't qualify for adjustment of status. If you have a U.S. citizen parent or a U.S. citizen or resident parent, and you don't qualify for adjustment of status because of the overstay issue, and because you don't qualify as an immediate relative of a U.S. citizen, then or you cross the border without permission, then this waiver will allow you to get forgiveness for the overstay and what we call unlawful presence. You get forgiveness for it, and then you stay in the US for the time that it takes for the petition to be processed, which if you're, it depends on your age and what category you're in, the length of time it will take. But you'll first have to wait for the petition to be approved, the petition that your parent filed, or even if you filed for VAWA, you have to wait for that to be approved. But VAWA, you get to stay here, so that's not an issue. If the parent is the one that files the petition, then you have to wait for it to be approved. And then from there, once it's approved, and then your priority date becomes current, you have to apply for the waiver, the I-601 waiver to get forgiveness. Once that's approved, the whole time you get to stay in the US, once that's approved, you are then able to take that and go to the interview at the embassy in your country. At that point, as long as unlawful presence or the overstay is the only immigration violation that you have on your record. So you don't have misrepresentation, you don't have anything criminal that's going to render you inadmissible. It's only the overstay. Then at that point, you are able to go to the interview and have enough confidence to know that you will be able to be approved for your immigrant visa to come right back to the United States within a matter of weeks after the interview. So maybe 2 to 4 weeks after the interview, you'd be able to get your immigrant visa and come back to become a permanent resident and move forward with your life. So that's the alternative if you don't qualify. So, for example, if you're 21 or over, you're here without status, you already overstayed. Now your parent filed a petition, and now you are getting notifications that they're ready to process your application. At that point, you're able to take advantage of the I-601A process. Now, the I-601A process is dependent whether you're going to be approved or whether you have a good case for an I-601A process is also going to depend on whether you can show that your parent will experience an extreme hardship if you don't get the green card. So it takes a lot of work. It's not just completing a form. So if you're in a situation where you're here, you're out of status, you would like to figure out a way to fix your status and stay here, or a way to get to the green card, then go ahead, give us a call, schedule your appointment, and I would be more than happy to evaluate your situation. As you can see from this live, this seemingly simple question of having that you have a U.S. citizen parent, you're here in the U.S., can you stay and apply for the green card? It depends. We can go down a number of different paths, just dependent on so many different factors in your own circumstance. So this is where the consultation is very important. To get in touch with me on YouTube, on Facebook, and Twitch, you will see the number going across the screen. And also in the description of the video, you see the link. Just go ahead, click on the link to schedule your appointment. And on Instagram, just go to the link in the profile and you will be able to get all the information you need to schedule your own appointment. All right. So I'm going to go ahead and answer a few questions here. I'm scrolling through now. Hi there, Millie. It's nice to see you. My cousin would like to file for my uncle. What would be the first cost? So I'm assuming if your cousin wants to file for your uncle, the cousin would have to be the child of the uncle. So it would have to be a parent-child filing. The child has to be 21 and over and a U.S. citizen to file for their parent. Now, my cost, I don't give quotes on the live just because every situation is different. And so we have to do a full evaluation of your matter before we give quotes over the live. So this requires first a consultation. The consultation is $150. And this is for a detailed consultation to discuss your options and to be able to properly advise you. Now, afterwards, that's where you do get the full quote. I'll be getting married to a citizen in the US. I have a daughter who is 12 years. What is the procedure for her who is not his child? So, great question. So, your spouse, when you get married, your spouse will be that 12-year-old, your daughter's step parent. Now, in the case that you got married, as long as you get married before your child turns 18, the step parent, the U.S. citizen step parent, and the resident step parent can file for the stepchild. So as long as you get married before, you don't wait until your daughter turns 18 to get married, which I don't think that's going to be the case here, or that's not your intention, they can go ahead and file for them as their child. And it would, right now with your child, if your child is in the US, you could be looking at a matter of months to get through the process. So 6 months to a little over a year. If they're outside of the US, you're looking at about 18 months to 2 years for your daughter to get through. My mother's a citizen and filed for me, and it's 12 years now, and I am married. So it is taking about 12 years for married children of citizens to get through. So your priority date is probably coming up soon. If it hasn't already come current, you should log into your NVC account, because they do give you the ability to log in to check to see if they're ready to process your application and if your priority date is now current. How long does a filing take if your parent is a green card holder to file for a child who is over 21 years old? The child is outside of the US, so you can expect about 5 to 7 years right now. Can a US citizen who married twice before and got the naturalization through that marriage then remarry and is now divorced from those two previous marriages sponsor the now fiance? So, whenever if you get married, so once you become a US citizen, then you can file for whoever you would like. So once you get citizenship, then you're fine to sponsor a fiance, despite your past marriages. But keep in mind that these facts are complex, and I'm going very quickly through. So I'm not giving you specific legal advice. If you have any doubts here, this is where you get representation. However, once you've gotten citizenship, you can apply for anybody you want to, your fiance or your spouse. It doesn't stop the immigration service, though, from looking at your past filings, and sometimes maybe even raising questions or doing more of a review of your past marriages, because they can, if they spot anything suspicious, they do have the ability to investigate further. And sometimes, going through multiple marriages or going through a past marriage where you got married and divorced very quickly and then got your naturalization, it can raise questions. But generally, once you become a citizen, you are able to then move forward and sponsor your spouse or your fiance. So if you're in your 40s and undocumented, then your parent who a green card can't do anything for you. So if you're in your 40s, you're undocumented, your parent can file a petition on your behalf, and then when it gets approved, you'll have to go through a waiver process. But if you're already undocumented, it's unlikely that you'll qualify for adjustment of status. If you have submitted an I-485 from January and still haven't received your receipt, the money leave your account, can I contact USCIS with a receipt number to quote, or where do you contact? So yes, go ahead. If you have any questions, go ahead, contact the USCIS, let them know that you have not yet received your receipt number. And the contact number is on the website. So my friend and her husband went for their interview and was denied twice. What can they do? uh, like what's the next step they can take? So there is a serious problem here. If they're denied twice, they need help. So your friend and her husband needs an attorney. They can always get in touch with me and I can determine. So number one, what's the reason for the denial? Is it something in the spouse's record? Is it something regarding the friend's past? Is it that they're not accepting that this is a bona fide marriage? So this is where it's time to invest and hire an attorney. All right, so this is going to be it for me today. Thanks everyone for joining me. Thanks for your time. I will be back again tomorrow with another topic, and you come with your questions. I'll be more than happy to answer those questions tomorrow. So if I did not get to your question, go ahead and come on tomorrow and I'll address those questions. In the meantime, as you can see, based on the complexity of that seemingly simple question that I answered today, it is always best to get legal advice. And keep in mind that the information on this live is not personalized legal advice. You're best to get that in a consultation, and you can always get in touch with me by going to the link in the profile. You can schedule your own appointment, or you can call the office and speak to a staff member, and they'll be more than happy to assist you to schedule your appointment. I look forward to helping you, and I will speak with you soon. Have a good one. Bye bye.